Welcome. If everyone could please take their seats. On behalf of the American Society of International Law, I'd like to welcome you to the 6th Annual Charles N. Brower Lecture on International Dispute Resolution. Charles Brower is a longtime leader and supporter of the Society in so many ways with respect to this lecture, but innumerable other ways. The lecture, as I just said, was started 6 years ago, and it's featured a distinguished array of speakers, starting in 2013 with Johnny Veeder from Essex Chamber Courts, then in 2014, Sundaresh Menon, the Chief Justice of Singapore, 2015, Michael Riesman, 2016, Gabrielle Kaufman-Kohler, and last year, David Caron. His remarks at this podium a year ago were referenced just yesterday by Judge Donoghue in her gracious address. And of course, this entire meeting is dedicated to the memory of David. We'll be remembering him in more detail later on at the Assembly, but I couldn't introduce this lecture without pausing for a moment to acknowledge the effect that he's had on international law and on all of us. But now let me turn to introducing our 2018 lecturer. Meg Kinnear, known to many of you, is the Secretary General of the International Center for Settlement of Investment Disputes, or ICSID, a member of the World Bank Group. Before taking her position at ICSID, she was the Senior General Counsel and Director General of the Trade Law Bureau of Canada, where she was responsible for the conduct of all international investment and trade litigation involving Canada, and also participated in the negotiation of bilateral investment agreements. She previously served as chair of the negotiating group on dispute settlement for the Free Trade of the Americas Agreement, and her prior government service included time as an executive assistant to the Deputy Minister of Justice of Canada and counseled at the civil litigation section of the Canadian Department of Justice, where she gained experience appearing before federal and provincial courts as well as arbitral panels. Meg has a Bachelor of Arts from Queen's University, a Bachelor of Laws from McGill University, and an LLM from the University of Virginia School of Law. I won't go through her publications, but they are numerous. Meg, we are looking forward at this very interesting juncture in the life of international dispute settlement and investor treaty arbitration investor state treaty arbitration, to hear what you have to say. So without further ado, please join me in welcoming Meg Kinnear.
Thank you, Lucinda. So good afternoon to all of you. I would like to start, first of all, by thanking Judge Brower and the Executive Board of ASIL for inviting me to present this lecture today. As Lucinda has noted, Judge Brower's leadership in international arbitration and his contributions to our field are truly too large and too great to mention, so I won't go through all of them. But I do want to go through one thing that I think is particularly special, and that's to mention Judge Brower's great dedication to mentoring the next generation. I know many counsel, and I think many counsel even in this room, have benefited from him teaching them the craft of lawyering and the skills of critical thinking and rigorous analysis, and that is a real gift forward to the next generation. Judge Brower has also been a tremendous supporter of ICSID, and he has made himself unstintingly available to give us advice and also to give me encouragement. And whenever he gives me encouragement, the last thing he says, and I quote, is, "You can do it, kid." And I want to say that that has meant a huge deal to me, not only because it's nice to get encouragement, but also because I am absolutely thrilled when somebody thinks that I am a kid. So I thank you on both counts, Judge Brower. I would also like to remember David Caron today, who, as Lucinda has said, certainly set a great path for all of us, and while we miss him, it is wonderful that we have had the chance to get to know him over a little bit of time. I also find today's task a little bit intimidating, especially following in the footsteps of somebody like David Caron and the other Brower lecturers. But I hope that what I say today can contribute at least a little bit of a different perspective to the discussion on the future of investment dispute settlement. Like you, everything I read and hear on this field is peppered with very dramatic language. It's a backlash, a crisis, a chaos, abandonment of the system. And I have to say that I have trouble reconciling that kind of narrative with what I see and what I hear on the ground every day. From my vantage point, the clear majority of states recognize the importance of investment agreements to encourage investment promotion and to encourage protection of investors when they go abroad. And they very clearly recognize and value investor-state dispute settlement because it solves some very real large problems that otherwise would be political problems or might go unresolved. And from my vantage point, what states are really interested in right now is a pragmatic discussion on what works and what doesn't work in practice. So at ICSID, we have started a process to amend our rules in an effort to do just that. What we want to do is play a part in making the system better, but in a very tangible, concrete, and pragmatic way. Now, of course, that is easier said than done, and so I am going to take the opportunity of today's lecture to tell you a little bit about what we are doing, the challenges we face, the opportunities that we see, and hopefully to get some input from you, if not today, at some point as we go along in this process. Now, let me give you just a little bit of a brief history. The last rule amendments at ICSID were 12 years ago, from 2004 to 2006. That process led to some very innovative provisions that I think have fundamentally changed investor-state dispute settlement. Think about, for example, public access to hearings, public access to case documents, participation by non-disputing parties, the mandatory publication of awards, and early dismissal for lack of legal merits. Those are all things that didn't exist, certainly when I was practicing investment arbitration, and they were all things that are every day at this point. They are a common part of our discipline. So it seems to me that because of those initiatives, ICSID arbitration has really started a new generation and some of the changes, and has proved that it can change with the times. And I believe that a lot of the success of that round of amendments was attributable to the process. And in particular, it was a very inclusive process with a lot of input from states, practitioners, and the public. So when we announced the current amendment process in October of 2016, we started with the thesis that there had to be broad consultation. And we made a commitment to ensure that all interested stakeholders could comment on the ICSID rules, on the potential amendments, and how practice ought to change. We recognize that that may be opening a Pandora's box. We recognize that there will be differing views. And by definition, not every commentator and even not every state is going to get everything that they want out of this process. And that really is the fundamental challenge for us. How do you manage this process to make sure that you can get the consensus you need and to make sure that you can move forward and have an impact on the new face of investor-state arbitration? I don't have the complete answer, but one of the answers is, first of all, engagement, and in particular, engagement of the states who, at the end of the day, are the ones who vote. The second, of course, is constant consensus building. So in terms of engagement, we asked every single ICSID state to designate a special representative to an amendment working group. And we specified that we wanted someone who could contribute substantially to the process, someone who would understand the relevance of proposed changes, and someone who could advise authoritatively on what their government's position was. And while we're very aware of the resource drain on state officials, we believe that this process can yield some real results in a short time. So we have impressed upon our states how we very much encourage and want their participation in this endeavor. So far, the take-up has been excellent, and it's interesting to me because I hear a lot of state representatives feeling enthusiastic about this. They see it as a real opportunity. We have had now more than 75 states name one or more representatives to our working group, and more than 40 states have sent us ideas on the direction that they think amendment ought to go in. We have also published and invited submissions from anyone in the public, and we have put these on our website. And we've received a number of those submissions covering a very broad range of topics. To all of those who took the time to submit, I want to personally thank you very much and assure you that our working paper has taken into account every submission that we have received. In addition to those inputs, the ICSID Secretariat has been keeping a list, and I know people talk about all the lists that we must keep at the Secretariat, but we have been keeping a list of things that happen in practice that might be ready for amendment. So we took our feedback from our states, our feedback from the public, and our list that we've been compiling for a while. We pulled them all together and said, here's the scope of what ought to be covered in the amendment. And to my great relief, there's actually a fair amount of overlap between the three sets of lists. So we have a good indicator of what direction to follow. In parallel, we established a rigorous internal process, and we set up working groups of ICSID Council. We had more than 20 basic topics, and every group was basically charged with going out and studying the comments received, looking at the history of the rule, any kind of case law, and then coming back with proposed changes. And they would come to a meeting of the whole and explain what they thought ought to happen. And I can testify that this has produced some of the most interesting, and I have to admit, perhaps some of the most intense discussions I have seen in quite a while. And it underlined for me, once again, in our line of work, we take procedure and process mighty seriously. So these were quite the discussions. After those discussions, the paper would be reviewed, it would be revised, it would go through the Deputy Secretary Generals to me, and then to what's called our internal scrub committee. So we are now at the stage of finalizing proposals. And this is going to result in a working paper, which is going to be released towards the end of the summer in 2018, this summer. That paper will be made available to member states and publicly available on the website. In September of 2018, we are holding a 2-day consultation with member states, and over the fall, there'll be numerous webinars and regional consultations to get further feedback and explain the proposals. We are also inviting any written feedback from anyone who's interested or piqued by curiosity about these provisions, and we are asking for that by December 28th of 2018. So if you are interested in letting us know what you think, put that December 28th date on your calendar, and we really do welcome your proposals and your thoughts. Now, my prediction is at the end of this whole process, we are going to get a number of comments, and I think they will broadly fit into 3 categories. The first is easily agreed upon. The second is to be discussed further, but has the seeds of something that might work. And the third is, the way I've titled it, unlikely to be agreed upon at least in my lifetime. So we will roughly pull these categories together and take those first 2 and pull together how they, what the feedback was and what the final package ought to be. We know that we have to garner consensus for an affirmative vote by 66% of the members, and so hopefully that will provide the ability to do that on that document. If we need to do further consultations, we will, but we are waiting to see the kind of feedback we get and where we stand at that point. Ultimately, a package of amendments will go to the ICSID Administrative Council for a vote, and our target is at the annual meeting in October of 2019, or if further consultations required, in 2020. Then once the rules are approved, they should go into force a few months thereafter. So at least in international terms, it's a relatively eclipsed period of time. As we draft, we have come up with a few ground rules, and I think they're important so that you understand our approach when you finally see the document. First of all, we are committed to keeping the ICSID rules balanced as between investors and states. And while it's only member states who ultimately vote on the rules, we are urging them to assess the proposals from the perspective of state as respondent, but also the perspective of investor as claimant, and to make sure that they keep the balance. Second, we are trying to resist the temptation to over-regulate, and sometimes it is a huge temptation. But as part of not over-regulating, we are keeping in mind that sometimes some issues perhaps are better dealt with not by a strict rule revision or putting a new rule, but perhaps by a guidance paper or a sample precedent or those kind of materials. And in a way, this mirrors the soft law and the success of soft law tools that we've seen in international arbitration, things like the IBA guidelines on production of evidence or conflict of interest. And we are finding that this is useful in our context as well. So we have already drafted some of these guidance notes, and we're developing more in tandem with our proposed rules. So the approach then is, let's have some broad rules that have durability and can address today's situations as well as the ones that are going to come up in the future. The third running rule is about drafting style. And the mantra at ICSID these days is plain language and say it simple. So as part of this clear drafting, we have also adopted a policy of gender-neutral drafting. And I want to assure you that we are not using the open brackets him/her close brackets format of gender-neutral drafting. I also want to assure you that this is part of the broader outlook at ICSID and not just my bemusement at officially being called he for the last 9 years. We are also drafting in English, French, and Spanish, our 3 official languages. And that's a very interesting thing. We frequently find that we start with a text and we think we have it nailed down, and one of our colleagues says, that won't work in Spanish, and we are back to the drawing board. So it is a challenging but a very interesting endeavor. Now, with these ground rules in mind, what about the actual playing field? In many ways, it's shaped by the particularities of the ICSID regime and by the broader investment law context that we work in. The most obvious consideration, of course, is the ICSID Convention. As you probably know, the ICSID Convention is basically a mix of broad governance clauses, a general framework for arbitration and conciliation, with a few specific rules that apply in arbitration and conciliation. And frankly, looking at it today, you might have expected some of those to be in more technical rules as opposed to found in a constitutional type document like the Convention. Now, the Convention can be amended by the vote of all member states. That's right, 100%. The Secretariat is not proposing to amend the Constitution, the ICSID Convention at this point, or to take on that 100% requirement. But something that may be a little bit new is that quite clearly Convention amendments are in our overall vision and perhaps as part of tranche 2 once we get through this process. We're well aware that the traditional logic is this can't be done because it never has been done. But the fact is, Convention amendment has never been sought, and we now have 50 years of experience, and member states may well be ready to contemplate some Convention amendments. So something you will see in our working paper as it goes through is flagging specific areas that might be apt for Convention change as part of tranche 2 of this overall look. So on that list, you might see things, for example, like enlarging the panel of arbitrators and conciliators. Currently, states can only appoint 4 to each list. The fact is, with more cases, more linguistic requirements, the need to avoid conflicts, and the goal of greater regional, gender, and other diversity, it would be extremely useful to have a larger panel. Another example you might see is changing the requirement that parties must consent to publication of an award. To date, this has been dealt with either by publication or by extracting, but maybe it's time for that to change and for publication to be required without any requirement for consent, but simply published. A third one that I think many will say perhaps it's time to change is the rule that co-arbitrators must decide the challenge of a third arbitrator. This, of course, has been frequently criticized, I think at almost every presentation I've ever made, to be honest. And even though it represents best practice of many international courts, it is a bit difficult in an arbitration system. So those are things that well could be in the tranche 2 looking at convention amendments. By contrast, the ICSID rules themselves can be amended by a majority of 2/3 of the membership. We have 153 members right now, so we require 102 affirmative votes. The simple way that I put that, and which sometimes scares me, but is the challenge, is that means anything that's proposed must be acceptable to at least 66% of the states voting. This is probably a good constraint because it ensures that there is some multilateral buy-in to the process. Nonetheless, garnering consent and working within the boundaries of the convention clearly influences what is and what isn't possible. Now, there's also an external context. And of course, the rules don't operate in a vacuum. The most obvious example of this is the interaction between BITS and the ICSID rules. You have seen, and I think this is one of the trends of recent, a tendency for states to put more procedural provisions in their BITS. And of course, under the rules of treaty interpretation, where these overlap, it will be the BITS provision that takes precedent. In many ways, this is actually a good thing because I think this gives a little bit of leeway for those situations that will come up where an amendment perhaps is not as extensive as a state might like, or where an amendment does not succeed because it doesn't garner the 66% approval. At least states can somewhat personalize those kinds of things in their treaties. The Mauritius Convention is another interesting example of the overlap with the rules and with the convention. I think from a substantive perspective, the Mauritius Convention, it's fairly easy to understand what the effect is. Essentially, if two states have ratified the Mauritius Convention without reservation, and if one of their nationals is suing one of those states, those rules will apply to all arbitration, in particular to the ICSID case. What's more interesting to me is the process perspective. And the pertinent lesson from Mauritius relates to the whole technique of opt-in or opt-out. I think as any of you who followed that Mauritius process know, probably the single most important step to getting agreement to the Mauritius Convention was the ability for a state to opt out by not ratifying or to take a reservation. We've thought about this, and the problem for, at least in the ICSID context, is that this kind of safety valve is not available. The ICSID rules are analogous to a single undertaking in a trade negotiation, where essentially a state adopts the ICSID rules as written when it signs the convention. So once again, we come back to the need to get some consensus. Now, although we can't use opt-in, opt-out type techniques, there is something that makes these rules very interesting, and I think will make them especially effective, and effective unlike any of these other documents we've seen of recent. And that is the temporal scope of application. And simply what I mean to say there is that the ICSID Convention provides that arbitrations and conciliations are conducted in accordance with the rules applicable when the parties consented to the proceeding, unless the parties agree otherwise. And essentially, what this means is that the new rules will apply likely to the majority of cases commenced after they are approved by the Administrative Council. Now, that's especially significant in the treaty context. We know that about 95% of treaties that are in force right now were concluded before 2010. We know virtually all cases pending right now are based on treaties negotiated before 2010. and many of them have contents that would be often considered first generation or second generation. So while our rule amendments can't address substantive provisions, they are certainly going to be able to supplement procedural provisions that are not found in early treaties. So this provides a real opportunity to modernize procedure in some of the old stock of treaties. Another big advantage, frankly, is that the ICSID rule changes can be made relatively quickly. And again, I contrast this with Mauritius, which to date has only been ratified by 3 states, signed by 22 states, and yet the negotiations were some 4 years ago. So I think our amendment process gives an opportunity to do something concrete and to do it relatively quickly. We also all know that there are several multilateral discussions ongoing about investment arbitration and investment law. You have the UNCITRAL process, you have an UNCTAD process, and OECD has regular forums. One could fairly expect, I think, or predict, that these will probably take a bit more time than the ICSID rules. And so I think we have the opportunity to be sort of a first mover by getting the rules done by 2019 or 2020. So with all this in mind as the background, what types of proposals are you going to see in August? Let me give you a random sampling. First of all, of course, you are going to see a much more simply worded set of rules, reorganized to deal with each topic in one place in a sequential manner. The downside for those who practice in this area is you're going to have to learn a whole new set of numbers, because a 41.5 will perhaps be a 22.3 or whatever, but it will all fall in place very nicely once you see how they are sequenced. Secondly, we are making a recommendation that claimants expand the information in requests for arbitration. So, for example, more detail on the facts, the damages claimed, perhaps even information on the proposed appointment or naming the claimant's arbitrator. While this is obviously not relevant to registering the claim, it is important, first of all, to try to move the case forward and for the respondent to know, what am I facing, and is this something where perhaps there's a jurisdictional issue, or I'd want to bring a 41.5 motion, trying to give them a bit more of a hint about what is coming. I think states will appreciate that. What I suspect claimants will especially appreciate is that we are also proposing that claimants be given the option of designating their request for arbitration as the first memorial in the case. And that in many ways allows them to fast forward the time easily 4, 6, or 8 months. So this is one of those kind of innovations that we think is going to be useful and welcomed by the profession. Thirdly, we have a lot of provisions geared to decreasing time. One of them is a general obligation to proceed in an expeditious manner, and it's an obligation shared by the parties, the arbitrators, and the center. Secondly, we have a number of specific provisions where we have suggested time limits or put time goals attached to certain steps and next steps. So we hope this will be effective. I should also add that there are a number of those sort of informal soft law tools as well that we are using in terms of moving the cases forward more quickly. Fourth, there is a presumption that all filing is electronic because our banker box collection is huge. And so from now on, it is going 100% electronic. Fifth, with respect to constitution of tribunals, if you've constituted an ICSID tribunal, you know that there's a bit of a complicated formula in Rule 2 about propose and respond, propose back. That section is being X'd out, and we are simply saying we need the tribunal constituted in 90 days, and if that hasn't happened, you can invoke the default appointment scheme. Sixth, we are requiring arbitrators to file a much more elaborate declaration upon acceptance of appointment and requesting more detail in particular about the relationship to the parties, to the council, to co-arbitrators, and to funders. We are also requesting much more detailed information with respect to calendar and availability. Seventh, on disqualification, there are a number of changes that we can make that are not limited by the convention, and so we are doing this. So for example, right now the rules say you will challenge promptly. There have been all sorts of cases about promptly. We're replacing that with a set period, 20 days. Make this much more simple. Another change to the disqualification rules is that we are removing the automatic suspension of proceedings when a challenge is filed. And this addresses a number of comments that we got raising concern about potential abuse of the challenge mechanism and repeat challenges on the same grounds and challenges on the eve of a hearing. So from now on, a challenge does not stay the proceeding. A tribunal has discretion to give a stay, but it doesn't stay the proceeding. So we think that will also be helpful. On transparency in publication, this is obviously one of the most difficult areas where context is extremely important. Again, we have the issue of first the Mauritius Convention and where that applies and supplements the ICSID rules on transparency. But we also know that transparency is very much a motherhood policy issue for many states, and I say that not just those in favor, but also those who are not in favor of that kind of approach. And that is where we will have to rely on a lot of pragmatism and willingness to compromise among our member states. Our current thinking is that the most important aspect of increasing transparency is ensuring decisions, orders, and awards are made public, and that those documents being public does the best service to increasing consistency and coherence, which of course is one of those major concerns expressed in the comments received and generally when you read about investor state. So the document that we issue is going to focus on mandatory publication of decisions, orders, and awards, and propose leaving publication of other documents such as pleadings to the treaty-specific obligations or to the agreement of parties. A last specific example is costs. The proposal suggests that we keep the basic rule at ICSID, which is costs are completely in the discretion of tribunal, but we are going to expressly set out some criteria that should be considered when issuing costs. And of course, the two most obvious ones are the outcome of the proceeding and the conduct of the parties. So while we're not going to one of those strict cost follows the event rules, we are trying to make sure that those criteria are actively considered in allocation of costs. So that's a little bit about what will be in the working paper. Let me tell you a few things that will not be in the working paper. Number one, the working paper does not propose an appeal facility or a standing tribunal. We know this is a topic under discussion at UNCTAD and UNCITRAL, and we know that no consensus has emerged yet. However, we believe that as currently framed, the rules on appointment provide that parties stipulate the method of appointment first and foremost, and our rules only take effect if you are in a default appointment situation. So this means that our rules, as currently written, should be able to accommodate a number of options. For example, is there going to be a mandatory list, institutional appointment, appointment by a designated authority, or some other method? So we will all have to see and wait and see where these discussions go, but we think that there's a lot of capacity for the system as it's currently written to accommodate those kinds of changes that states might decide on. The next question is the famous question of double hatting. The working paper is not going to outlaw double hatting. What it is going to do is deal with this question by proposing greater disclosure in the arbitrator declaration. So this means there will be no broad, no double hatting. It means, though, that the fact of double hatting, and what I think is most important, specifics about what each hat looks like, is going to be disclosed early. And hopefully that will allow you to avoid conflict, and secondly, to raise a challenge at an early date if those specific facts justify that kind of a challenge. So that's how we will propose to deal with that issue. Similarly, one of those other issues or hot button issues that we hear about is third-party funding. I know some commentators would prohibit third-party funding outright, but that is not going to be proposed in the working paper. This reflects the fact, of course, that third-party funding is legal in many states, and that many see this as an access to justice issue. At the same time, there is a legitimate concern about potential conflict of interest, and again, that is the aspect that we propose to address. So the amended rules are going to deal with third-party funding by requiring two things. First of all, upon registration, that each party, both claimant and respondent, advise whether there is funding, and secondly, that arbitrators disclose whether they have any relationship to that funding. And the matter, if those things turn out to be affirmative, then gets dealt with by the tribunal on the basis of that specific case. Finally, there have been questions about an expedited claim process. Now, the working paper does not propose the kind of expedited claims rules that you've seen in some of the commercial rules, because our feeling was you couldn't simply take an investment case and say, that can fast track, that's slow track. So what we are trying to do, essentially, is build in different places where you can fast track if the case is amenable to it. So I just gave you that example of designating the request for arbitration as your first memorial. There's an opportunity to fast track several months. And we're putting a number of those options into the rules, hoping that they address concern about time and cost. So the bottom line is that the proposals for ICSID rule amendment are a real opportunity to continue the evolution of investor-state dispute settlement, to do that in a relatively short period of time, and to do so with respect to new ICSID cases involving all 153 member states, so it can have a significant impact. While there are some who might prefer a more radical approach, I think there's a lot to be said for pragmatism and effective change that happens, even if it's taken in small steps. And I think that if Mick Jagger of Rolling Stones fame were the Secretary General of ICSID, he might summarize this as follows. You can't always get what you want, but if you try sometimes, well, you just might find you get what you need. I don't think I could say it better than Mick Jagger, so I'm going to stop now, but I would like to thank you for your attention, and I would be delighted to answer any questions. Thank you. Any brave souls? All right. Well then, if you think of something, sorry, Anthea.
I think I'm on. So I wanted to thank you very much for that. That was an excellent overview. The way I've been looking at the reform of ISDS and the championing for reform of ISDS has been to basically divide the groups into three. You've got those who are interested in incremental reform of the existing system. You've got those who are interested in systemic reform to create something that still has investors suing states, but not with the arbitral model. And you've got those who are after revolutionary or transformational reform, who think investors should not be able to sue states at all, be it before an arbitration or before a court. And state-wise, I would tend to put US query, we're not sure, and Japan as the incremental reform camp, the EU and Canada in the systemic reform camp, and those like South Africa and Brazil in the sort of transformational reform camp. I think I line ICSID up very clearly with the incrementalists, and I think that what you've just set out is an exceptional approach to how to do incremental reform in a way where you can really improve the existing state of arbitration. I also think you've been incredibly diplomatic in the way in which you have put this across, putting forward the positives of the incremental reform with actually very little discussion of the other two options. But I'm actually kind of interested in the impact of the other two options on pushing for this reform. So one of the things I think is an interesting dynamic is Is it because we now seriously have on the table before UNCITRAL the possibility of systemic reform? Has that been a push to give sort of more speed or more precision to this idea of incremental reform? Would we have had the same debates about incremental reform if we had not had that on the table? And I'm sort of interested in the relationship between the systemic and the transformational with pushing for the incremental in the way that you have just done.
Yeah. It's interesting. I mean, I agree, you could probably put us in the category of incremental if you want to pick one of those categories. But I also think that a lot of what exists in our system will accommodate systemic reform if it happens. So obviously, depending on what the exact format is, but I don't discount that possibility. So there's a lot to be seen and watched as we see those other processes ongoing. And you may have seen that, for example, ICSID is named as the Secretariat in the Canada-EU Agreement, is named as appointing authority, et cetera, in the revised, the CAP, TPP, and we are increasingly playing that role. So we are certainly trying to make sure that we can service the need for investor-state dispute resolution, and whether it be in the form of arbitration as we know it today or in some different form, I hope that we actually have the capacity to change and move with that. Whether all of these things happening in the environment were part of sort of the impetus to doing these reforms, yes and no. I can say that the sort of running internal listed ICSID has been around for about 4 or 5 years, and we were getting to a point where we wanted to do that. But I think as much as anything, maybe what caused us to make the final decision or pull the trigger was very much our sense that here are all of these states facing, as you say, potential, if not revolutionary reform, perhaps systemic reform, and a sense that a lot of them were wanting to know better, is that the way to go, and are there other options? And as we thought about it, yes, there are other options, maybe exclusively or maybe as a complement, but that's in our hands and that's what we're going to do. So I think that was really the sort of thinking behind it.
Whitney Debevoise, Martel and Porter. Thank you, Meg, for that explanation of the process, which is very helpful. I believe that as a result of a request at an earlier administrative council meeting, the Secretariat was going to undertake a study of the incidence of occasions when claimants that had cost awards entered against them, in fact, had not paid the cost awards. Could you tell us the results of that
Absolutely. For background, at the annual meeting where we announced the rules reform, there was a request by Panama to look at the situation where, for example, a state had defended in good faith, had received an order of costs, and then was unable to have their costs paid, and so ended up bearing the brunt of that bill at the end of the day. And Panama made a request that we look at this and think about potential amendments to deal with this. And what we decided we would do was to do a survey among member states to try and find out how often does this happen, what was the extent of the situation, and when did this happen. So we sent out a survey to all of our member states about compliance with awards of costs and with other parts of awards. We sent out about 4 or 5 reminders, and in November of 2017, we published that, and it's on the ICSID website. What it said to us at the end of the day, and it was hard, frankly, to take a lot from it, but what it did say was that this was a problem for some states. It was not a hugely widespread problem, and what was interesting to me in particular was that a lot of states who found that they could not execute on their award did not bother trying to take it and use the simplified enforcement mechanism in the ICSID rules. Now, I suspect a lot of those situations were from earlier cases. I think states more often now are actually taking active enforcement measures when those kind of awards aren't paid. But the data did not come out overwhelmingly one way or the other. So I invite you to take a look at that. And obviously, we're glad to chat further about it. But we did do this survey, and that was the result that came back.
there are no further questions, please join me in thanking Meg for a very illuminating address.